Hello, everyone. My name is Oday Salim. I direct the Environmental Law and Sustainability Clinic at the University of Michigan Law School, and I'm a staff attorney for the National Wildlife Federation. As chair of the Environmental Justice Subcommittee, I am thrilled to guest host one of the chair chats for our section on civil rights and social justice. And I could not be more delighted to be interviewing Abre Connor. Abre is the director of the Center for Environmental and Climate Justice at the NAACP, and leads the Environmental Policy Clinic at the University of California, Davis. Among other positions, she is a member of the ABA's Children's Rights Litigation Committee and has also worked as an attorney for the ACLU of Northern California and for the Center on Race, Poverty, and Environment, and was the Chief Policy Officer for the ABA Young Lawyers Division. She obtained her law degree from American University's Washington College of Law. Our main topic today is one that various units of the ABA have focused on in other programming, namely the Supreme Court's 2023 opinion in Students for Fair Admissions versus Harvard. Specifically, Abre will educate us on whether environmental justice policy may be impacted by that opinion and that opinion's many progenitors regarding race consciousness in policymaking. Welcome, Abre.
Thank you so much for having me.
Of course. Well, first, before we get started on substance, I'd just really love to hear about your journey. What led you to become an attorney who is focused on environmental justice?
Yeah. Well, I grew up in the South. I grew up in Florida, and it was very obvious to me at an early age that there were differences in how people were treated, where people lived based on race and based on other categories that at the time, I didn't fully understand why, but I could tell that there was a difference that was happening. When I was younger, I had a number of breathing problems, and I thought it was normal to have an albuterol pump growing up. And a lot of the other Black kids that I knew also had breathing problems, and we would see smoke near our homes and where we lived. And I realized later that it was phosphate plants. And so there are a number of phosphate plants that were near our communities that they would place there. And oftentimes we weren't a part of those decision-making processes as to where these incinerators and where these plants were located. But we were very much, living a life of seeing what environmental racism looked like. But it wasn't just the decisions around like phosphate plants. It was all of the policies, all the decisions that were made that really kind of helped me to understand that the people who were in elected positions, who were in decision-making positions, that all of those decisions together could lead to individuals who are part of protected categories, such as Black folks, to live in communities where they weren't experiencing life in the same way as other individuals. I experienced a number of issues like school discipline issues based on really ridiculous reasons growing up as well. Like when I got called the N-word, and I got in trouble for telling the teacher that I was called the N-word, in discipline for telling our history teacher that the civil rights movement should be a part of American history, for example. And when you think about environmental justice, it may seem like, oh, it's really about plants and trees, but it's really about the community where people live and the folks who are making those decisions. And so what I realized by the time I got to high school was that I wanted to make a difference in the civil rights space. And so I went to college and I was like, okay, I'm going to do civil rights work. And then I realized that in order to change the laws that were a part of how we ended up there, it could be helpful to go to law school. So it wasn't necessarily that I always wanted to be a lawyer, because that I felt like law school was a means to an end. And then I understood at that point the intersection between environmental issues and those phosphate plants and where I lived, and the civil rights connection. And so that's what led me to environmental justice, was really understanding that the connection that I wanted to do around civil rights and racial justice was completely intertwined with an environmental conversation that needed to happen.
Thank you. And, I'm about to ask you for a definition of environmental justice, because there may be some people joining our chat today who are not intimately familiar with the concept. I can't imagine a better description of environmental justice or slash injustice than the one you just provided. But I guess let me rephrase it a little bit more narrowly. What legal definition of environmental justice should our audience be aware of, so that as we talk more about this topic, they can reference it?
I would say folks within the EJ community tend to look at EJ as the ability to eat, live, and pray within your community without any additional hindrances or burdens to be able to do that. The federal definitions, particularly now, as we're looking at, and hopefully we'll discuss later, certain environmental statutes, look at the protected categories, so race, ethnicity, disability, and religion. All of these categories ensure that those individuals are able to live within their communities without additional burdens or harms. And so that's the definition that I tend to stick with, the ones that definitely ensure that race and ethnicity are a part of the conversation. And a lot of the agencies now who are looking at environmental justice are recognizing that that has to be a part of how we're thinking about EJ moving forward.
Thank you for that. So, starting in the 1970s through about the mid 1990s, I think it's fair to say that most environmental justice law was comprised of civil rights litigation, equal protection litigation, Title VI litigation against, for example, counties who were citing too many toxic landfills next to communities of color, or municipalities, for example, depriving too many Black and brown neighborhoods of resources and public improvements. So, that litigation continues to this day, rather unfortunately. But starting in the 1990s, we see something a little bit different regarding federal and state agencies. We start seeing agency behavior, not just civil litigation, but agencies themselves, either directed by legislatures or on their own, tackling environmental justice policies. Why do we see that change suddenly in the 90s?
Yeah. So I would say in the late 1980s, we saw one of the most important reports that was drafted in the environmental justice space. And so like Charles Lee, which is widely lauded within the EJ space as one of the founders of environmental justice and really recognizing this intersection in the UCC church, they drafted this report called Toxic Waste, Toxic Waste and Race. And this was the first time that we saw on a very wide scale that you had these communities that were predominantly Black, predominantly people of color, where there were sightings of toxic waste incinerators. And what did that mean, right? So in 1987, we see that there are intentional decisions to ensure that the folks who already aren't receiving a lot of resources for a number of things, because it's the 1980s, so whether it relates to housing, whether it relates to government benefits, now we have a report that shows that they are more likely to be breathing in toxic air because of the toxic waste incinerators that are in their communities. So you would think that with this report, right, that that there would be a change as it relates to the companies, the industries that are actually placing these toxic waste incinerators in communities based on race. It was like 3/4 of the communities that had toxic waste incinerators were Black and brown communities. We see 20 years later, and I'll go back to the 1990s, but 20 years later, they did the exact same study, Toxic Waste and Race at 20, and they still saw that some of those decisions were being exacerbated, and they definitely still lived in communities where you had predominantly Black and brown individuals. But at the federal and at the agency level, there was at least a recognition then that, okay, we have this information and we need to do something about it. And when you have someone like Charles Lee, for example, who now is a part of like the agency structure as a senior policy advisor, you have someone who actually understands the underpinnings of how we need to make agency level change when it relates to environmental justice, who is now there advising them to say, hey, the EPA, who is supposed to be there to protect communities, can't actually do its job unless it's protecting the most vulnerable communities. The White House, who has not really ever said anything as it related to environmental justice, needs to actually ensure that as a part of the rights as it has relayed that it's trying to protect individuals across the country, that environmental justice is a part of those conversations. And so we saw for the first time, for example, that there was an Office of Environmental Justice in the EPA. And as you stated, for decades before the EPA had, kind of touted itself to be an agency that's supposed to be protecting people, protecting communities, but there was no focus on ensuring that what we saw in toxic waste and race, that would not continue to happen. And so I think that really was a pivotal moment. In addition to that, at the same time, you had Warren County, North Carolina. And around that time, there was a decision to allow for there to be almost 60 tons of PCB contaminated soil that was going to be dumped in this predominantly Black community. It gotten a lot of attention, even the attention of many civil rights leaders as well, to say, we can't actually have this conversation around racial justice without also talking about the environmental components. And so one of the past presidents actually of the NAACP, Ben Chavis, was a part of those protests as well, and was a part of the conversation to term the terminology of environmental racism. You had over 500 people who were arrested, right? Because they were saying, we cannot allow for this Black community to continue to have to live with even more contamination just because they're a Black community. And so at that time, we're seeing for the first time a really widespread and national effort from individuals from many different sectors saying, the environmental issues that we're talking about are also racial justice issues, and that we can't allow for this to continue without there being support from agencies, from the White House. And then we had President Clinton at the time, who signed Executive Order 12898, which for the first time, and it was a major action at that time, historic, for there to be a focus at the administration level to say environmental justice needs to be centered in the actions of federal agencies.
Yeah, thank you. And we saw federal agencies coming up with environmental justice plans. And then, of course, we see federal agencies exercising Title VI oversight over state agencies and making sure that those state agencies, environmental natural resources agencies, are paying attention to justice concerns. So I'm getting close to asking you to describe for us the holding in Students for Fair Admission versus Harvard. Just before we get there, because what we're trying to understand here is what might the impact be of that opinion on a number of, especially state level environmental justice policies and federal as well. So if you could actually just take a brief amount of time just to describe, what are we talking about when we say, I think we know what we mean when we say environmental justice, civil litigation, civil rights litigation and otherwise. But what do we mean when we say environmental justice policies at the within federal and state agencies? What kinds of policies are we talking about? What might be vulnerable to that opinion?
Yeah. Well, let's look first at Justice 40. And that has been, particularly for this administration, one of the most creative and innovative ways that I'd say the administration has tried to ensure that environmental justice is a part of funding decisions at the state and at the federal agency level. It basically states that 40% of credits, as it relates to a number of different funding programs that are funded by the federal government, that they have to have a focus on disadvantaged communities. Now, why is this important? In the past, most of these programs, they've just been able to operate in a way that has not only been harmful towards, Black and other people of color communities, but has exacerbated the problems, right? Because you'll have a state that gets funding, and then they choose to allocate that funding to already very well-resourced communities within their state. And then you have, for example, a place like Jackson, Mississippi, in the midst of a water crisis, who's asking for funding, and you have a governor who ignores them. And in the past, you had states that have been allowed to do that. There's been no accountability. There's been no way to kind of second check whether or not they're actually doing what's kind of within their purview and their right as a state as it relates to the allocations of funds. But Justice Forty said, hey, for the first time, we're going to actually try to make sure that there's guidance around how, if you're going to get the money, these are the ways that you need to ensure that it's rolled out. The way that J40 has been utilized, right now, the implementation is so important. And there has oftentimes been an overlay, especially that advocates and folks who are within the EJ community are able to clearly see, even if we're talking about income levels, or we're talking about other kind of categories that allow for us to see that a community is disadvantaged, that race is definitely a part of that conversation. Like, you cannot have a conversation around disadvantaged communities without having a conversation around race. And unfortunately, for all the good that Justice 40 has done, there has been some pushback because the administration has not necessarily wanted to include race. And so you have a program like that where it's unclear whether or not this is actually going to be an issue. However, race has always been a part of how people think about Justice 40, because it's silly not to. You also have permitting decisions that have been made recently. So, for example, there were 3 open complaints in Louisiana as it related to permitting that was going to be happening in Black communities. And around the time when we had this decision come out, the EPA and the DOJ decided to close those permitting complaints, which was really concerning for a lot of advocates, because the data seemed very clear that these Black communities, these communities who were disadvantaged, were going to be harmed. And it felt as though Louisiana was able to bully them into making that decision. We don't think that that's by happenstance, that it was also around the time where the Supreme Court decision was coming out. And then you also have these intended use plans, which I kind of alluded to before, but it's an opportunity. So the way that grant and loan kind of decisions are made from the EPA to the states is that states have to allocate funding. States have to seek approval from the EPA as it relates to how they plan to allocate funding across the state. And it's called an intended use plan. And in theory, the EPA should be able to say to the state, hey, we're looking at Justice 40, we're looking at a holistic kind of number of factors, and we think that the way that you're allocating these funds is not going to actually reach the communities that it should be intended for, right? The EPA has not necessarily utilized that authority as much in the past, but advocates have been pushing very strongly to say, hey, EPA, no more rubber stamping. They need to prioritize communities of color. They need to prioritize Black communities, Indigenous communities, Brown communities. And now with a decision like this, it definitely impacts how that advocacy is going to look. And that there's a lot of money that is attached to intended use plans to the states, and it gives states a lot of power to be able to say kind of what happens to communities at a local level. And recently, there were a number of revisions that the Council on Environmental Quality have been proposing as it relates to NEPA, including what it means to have meaningful public engagement with communities who need to be centered. And now that we have a decision where race is on the table, is that going to continue to be able to be part of the meaningful public engagement that has to happen, that the engagement also needs to happen with communities based on race as well. Well, of course, we're going to continue to push that, yes, it is, but that is definitely a concern. There are also a number of categorical exclusions that have been proposed under the NEPA, under those revisions, as to whether or not those categorical exclusions can be made for environmental impact statements. And race should be a part of whether or not a community, for example, has been historically harmed in a way that there cannot be a categorical exclusion to an environmental impact statement. But that is something that is, of consideration now. And then one other component, especially as it relates to the CEQ implementation of the NEPA revisions, is that race is actually a part of the definition that CEQ is considering as it relates to those revisions. And so we, are concerned, but we hope that CEQ continues to see the importance of including race in the definition of EJ. And I think that, at a state level, one of the things that's really important to keep in mind is that the federal kind of definitions, the federal kind of statutes, they're the floor. States can always have stronger, they can, for the most part, always have stronger protections. And so we do see certain states like New Jersey where you do have those stronger protections, and it's important for states to recognize that they can also be, a model when in a time where we are facing challenges at a federal level.
Yeah, that's a great point. I'm so glad you went over those different categories. So now we have an understanding of, the different kinds of agency permitting and rulemaking behavior that may be the subject of complaints related to this case that we're about to talk about. So now, without further ado, give us the sort of narrow holding in Students for Fair Admission, and talk about the broader principle that it stands for, that other case law that came before it helped set it up regarding race consciousness in policymaking.
Well, for years, race has always been considered one of the factors as it relates to admissions. And so we've had Grutter and Grutz, like we've had decisions where it's very clear that, it's a really important component of ensuring that there is diversity, ensuring that the students who are actually at the university, that they have a well-rounded and the ability to hear different ideas once they're actually at the university, that it's important, for the university at a holistic level to ensure that a lot of different individuals have the space to be there, and that you have some people who, just because of who they are, they've had more of an opportunity to be able to be at certain institutions. And there was a recognition that that's not necessarily fair, that's been the case. And so we had this very clear kind of decision, but Bloom decided to start this anti-affirmative action campaign that was aimed at removing race as just one of the factors that could be considered. And I think it's important to note, that it's not that oftentimes it's like the university is saying, oh, this is the only factor. It's one of the factors. And the fact that there was a campaign to remove just one of the factors, it says a lot about what this campaign meant to Bloom. And so in the majority opinion, Chief Justice Roberts outlined that the using race as one of the factors that as it stood, that it violated Equal Protection Clause and also Title VI of the Civil Rights Act. One thing to note, though, is that the court did share that if there is an exceedingly persuasive justification, if it's measurable and concrete, enough for judicial review, that also is potentially an opportunity to still use race. And the court also said that, it's not necessarily touching the mission of the university. So if the university decides to define a mission where it says that it's important for there to be a racial diversity at the university, that is not necessarily a part of the decision. And what's also really interesting to note as it relates to this decision is that there definitely were some concurring opinions as well, where it seemed as though the court was hoping to use this as an opportunity to look at many different kind of components of anything that deals with race. So looking at Title VI more broadly, looking at Title VII, looking at how Equal Protection Clause is used in other spaces. And that was a part of not just the majority opinion, but also some of the concurring opinions as well.
Yeah, thank you. And so I think really the big question for our chat today is, you just explained, that narrow holding. You elaborated a little bit on some of the holdings that came before and the broader principle. So for, let's say, a state legislator or a state regulator or someone who works for an environmental justice nonprofit, and they're all thinking about ways in which to legislate and regulate toward environmental justice, ways in which to alter permitting processes and rulemaking and participation ground rules to achieve better environmental justice. Should those folks be worried about Students for Fair Admission and the cases that came before it? Or is this much ado about nothing?
I think that this is an opportunity to ensure that advocates are coming together to be just as strategic as Bloom in his anti-affirmative action campaign was, to make sure that at the state level, at the local levels, at the judicial nomination level, at all of those different places, that we are thinking just as strategically as they were about getting rid of race. And so I think that what the decision was really a wake-up call to make sure that we're not just playing defense, but we're playing the offense as well, to make sure that we've set up all the different kind of components of a really well thought out strategy. It makes me think a lot about the Brown versus Board of Education decision, for example, right? It took a number of cases at the district level and campaigns at a local level to really get to the place where Brown was ready to even be brought to the Supreme Court. And I think that now is really that opportunity for advocates from a number of different spaces to come together, because I see it as an environmental justice issue, but I also see it as an education issue, right? They're utilizing Title VI. This is a housing issue. It's an issue that impacts many of our communities. And so I see it as a rallying call for us to come together. When I think about, judges, for example, as I was talking about before, really making sure that we're looking at senior status, like who is up for judicial nominations, and making sure they're filled with good judges who recognize the importance of race being used in conversations and in decisions as it relates to environmental justice. Really thinking through ensuring that there are statutes at a state level, like the New Jersey one, where they go further. And the more statutes, the more laws that exist like that at a state level, that allows for there to be more opportunities for people to do advocacy that maybe they haven't necessarily had the opportunity to do before. So we're not as reliant on just a couple of different statutes. There are other opportunities for people to engage. And then I'd say, right now, when you have the Biden administration who has recently come up with that executive order to say that environmental justice needs to be central to all federal agencies, that we really need to be able to utilize that executive order to say, okay, what can other federal agencies do to ensure that they are actually furthering environmental justice?
Thank you. One final question. In our conversation today, we've brought up a lot of different kinds of environmental injustices. I know you work on those a lot in your litigation role. When I teach my environmental justice seminar, I feel like sometimes I'm just talking about injustice after injustice, and it can get a little bit scary and depressing. So what I want to end on today is regarding environmental justice. What gives you hope right now?
I think what gives me hope is the fact that a lot of individuals who may come from environmental backgrounds, but also those who don't, are recognizing that they can be a part of the solution as it relates to environmental and climate justice. I didn't really mention this before, but I think of folks who are just constitutional lawyers in general. How can you use free speech or the First Amendment to further environmental justice work? And we saw that with like some of the pipeline litigation advocacy that's been done. That you have this next generation of individuals, when you look at the stats as it relates to younger generations and what they care the most about as it relates to voting, environmental and climate issues continuously come up as one of the top topics for what they feel is important. And even though we're lawyers, we're in the legal space, we also recognize the role of politics in all the work that we do. And so if we have generations that are coming up and they recognize that these decisions are going to impact them, I have hope that we have a generation that's coming, behind, that are ready to be radical, ready to be innovative, ready to be creative, to kind of fix some of the decisions and fix some of the problems that we have seen for years and years. I'm excited about what the future holds, and I'm excited that we have a number of individuals who are already kind of trailblazing those paths to ensure that hopefully we will have environmental and climate justice in the future.
And hopefully all of them sign up to be members of the ABA, right?
Yes, exactly.
Well, on behalf of the Section for Civil Rights and Social Justice and the Subcommittee on Environmental Justice that I chair, Abre, I want to thank you so much for joining us today and educating us. Thank you.
Thank you so much for having me.